weekly newsletter, please contact us and we're happy to get you on there. You can contact us at any point during the webinar at info@assetprotectionattorneys.com if you have any questions, or you can type them into the chat box and we'll try to get to them. We also do complimentary preliminary consultations with regard to estate planning and asset protection. Feel free to give us a call and we can schedule those for you. And if you have any groups of people that are interested in hearing about asset protection, and business succession planning, we can try to schedule one of our speakers to come and speak to your group. As I said, my name is Elise Gross, and I've been practicing for over 25 years in the estate planning and asset protection field. In South Florida, I'm an adjunct professor at Florida Atlantic University, where I teach wills and trusts to the paralegal students. I have with me today our special guest is Scott Roberts, who I'm going to introduce and have him tell you a little bit about his background.
Thank you, Elise. Just very quickly, again, Scott Roberts. I'm a CPA. I don't practice accounting, though. What I've been doing since 1993 is working with business owners and their advisors in the areas of estate planning, business succession planning, and the insurance planning that goes along with that. I'm also a chartered life underwriter, that's a CLU, and helping business owners along the way integrate all aspects of their wealth planning.
Great. Okay, so what I want to do today is just kind of give you a brief overview, and we're each going to cover certain topics and kind of integrate along the way. So what we're going to do today is we're talking about type of business succession, how to fund your business succession plan. We're going to talk some strategies for actually transferring the business and how it all integrates with the different tax savings tools. So just a few statistics for you. The average business owner retires at 71, and 83% of business owners actually want to see their business continue, assuming it's a viable business. With 80% of the businesses are never going to sell, they're just simply going to wind down and close their doors. And that's generally, sometimes when a business is solely based on its owner-operator, when that person either dies or becomes incapacitated, there's really not much left to sell. So one of the things we're going to be talking about today, and really the main point of business succession planning, is to see how we can actually extend the life of that business, either to other owners or to multiple generations. And only 33% of baby boomer companies successfully transition to the second generation. And actually, I know, Scott, these are statistics you've made. I would think that was actually lower. So I think 33% is not so terrible. And only 13% of the baby boomer companies go to a third generation. Sorry. Okay, so just a couple of things from an estate planning end. What every business owner needs, regardless of whether or not they're looking to have their business transition over to a new owner after their death or retirement, or whether or not they're planning on passing that down to another generation. So number one, it's critical that you have a power of attorney, a durable power of attorney for the business. It doesn't necessarily have to be the person that you name for any of your personal financial matters, but should you be out of town or you become incapacitated, you want the business to continue running as smoothly as possible. So it's very important that if you don't have another person who has the title of control, or whether it's a co-president or a vice president or somebody who can actually sign documents because they are a corporate officer, then you need to have a power of attorney naming someone to be able to sign things, checks so that payroll can continue, inventory can be acquired or sold, things of that nature. Another thing you'd want to consider having is, along with your business succession plan, you may want to have a revocable trust, which is a topic for another day, to make it more complicated, but for simplicity purposes, the revocable trust allows you to avoid probate on your business if you have the business, and it keeps things moving much quicker upon your death. The other thing you want to make sure of is, should you have income coming from the company and you become disabled, that income might go away unless you have, as part of your business succession plan, a replacement of that income. So you should definitely consider doing a disability insurance policy to at least compensate and replace some of the income. And lastly, great focus of what we do here is a good asset protection plan. Everything we're going to talk about today is how to transition your business from you. But if your business is not structured properly, then there's really no business to pass to another generation or to another owner. So having a good asset protection plan is really a cornerstone of, business ownership.
So we're going to talk a little bit about business succession in particular now. And the way to think about business succession or business continuity is that it falls really into three main categories. So you've got, each situation is going to be unique, but we can kind of group them into these three categories. The first one is the simplest to plan for, and that's where you have partners in the business. And you'll see on the next slide, you're really just talking about having a buy-sell agreement in place, and we'll talk a little bit about that. The second category is where you don't have any partners, but maybe you have family members. And really then your business succession plan is your estate plan. In other words, what's the way to most tax efficiently get the business and other assets down to the next generation. And then the hardest one to plan for is when there's no partners in the business and there's no family members either. It's a little murky, but there's still some things you can do. A little preview, the bottom line is you want to make sure you find the key person that can actually run operations when you step away. So the first thing that we'll talk about is the situation that probably the easiest. It's more clear cut as to what steps you should take to plan for the succession of the business, and that's where you have partners. So the first thing you want to make sure that you do is have a valid buy-sell agreement in place. Make sure that it's binding, and you do that for a couple of reasons. Number one, and I'll start it with that third bullet down there, is it avoids a surviving spouse becoming a shareholder, which is one of the main reasons that people put these in place. So if your partner were to pass away, would you want to be in business with his or her spouse? Generally, the answer is no. If you have a buy-sell agreement, it obligates you to buy them out upon their death. The second thing is that it ensures that there's an actual market for the value of your business. So most small businesses, very closely held. Sometimes there's a market for an interest in it. Sometimes there's not. This is a way to ensure that all the work that you've done throughout your lifetime, that value can actually pass on to your family because you've got a ready buyer, and we'll talk about how that can get funded as well. And then last thing, people don't think about this. If you are in an estate taxable situation, the buy-sell agreement will set the value of the business for estate tax purposes. And they've done some studies where over time, when you don't have a buy-sell agreement and somebody passes away, the length of time that it takes to haggle with the IRS as to what the value of the business was and what the taxable value, that can go on for quite some time. So that's just another reason that people don't think about it as much, but it's a real benefit.
Scott, let me just interject a second on this. On those buy-sell, if you set the value when you execute the buy-sell, what happens if the value goes up or down exponentially?
That's an excellent question, Elise.
I do try.
Typically, what you want to do is the way I like to arrange buy-sell agreements is where they start with a stipulated value in an exhibit in the buy-sell agreement. But then you're going to have language inside the agreement that says that if for whatever reason we have not updated this stipulated value within, say, 18 months or 24 months, then the valuation will then default to a backup plan. And that backup plan can either be a formula valuation if your industry lends itself to, say, 1-time sales or 5 times EBITDA, something like that. Or the other way you could do is it could default to an appraisal. And then, but then you also want to make sure that when you do the appraisal, you have even backup language there that says that if the appraisal gets done and somebody doesn't agree with it, then another appraiser gets hired, and all that is sort of spelled out in there. But yeah, that's how you deal with it. Good question. The second thing we'll talk about with respect to buy-sell agreements is something that people just sort of use default boilerplate language in documents and don't think these things through. So what kind of triggering events do you want to have in the buy-sell agreement? So the easiest one is death. That you usually want to have a mandatory buyout because, again, you're trying to guarantee a market for your interest in the company. And of course, if you're the surviving shareholder, you want to guarantee that you're able to purchase the deceased shareholder's shares. So that makes it pretty simple. It gets a little more complicated when you're talking about disability or retirement. And the reason being is that if somebody becomes disabled, first of all, there's this question of how disabled are they? Can they do some work, not others? So would that trigger a mandatory buyout versus not? And the secondly is that while death, you can fund for a buyout there with life insurance, and we'll talk about that in a second. With disability, they do have disability buyout policies, but they tend to be restricted in how much you can get, and they tend to be a bit more expensive than people are willing to pay. Actually had a client recently look into this, and they decided to forego the disability buyout insurance. It was going to be too expensive. So instead, what we did, and this is what I recommend people consider, is making the buyout upon disability just a first right of refusal. And so somebody has the option to do it rather than the obligation. And then you'll just deal with it at that point in time. And that's really the same thing that happens with retirement. If somebody retires, then you have the option to buy them out, but not necessarily the obligation. And the reason for that, think this through. Let's say you have a $10 million company and you own half of it and your partner owns half of it, and they retire. And then they say, okay, great, give me $5 million. Well, gosh, to pay them $5 million, even if you spread it out over 10 years, that kind of hampers the operations of the business.
Can you incorporate something in there where there would be income coming from the business to the retiring or disabled party?
You can, and I've seen that done where usually they limit it for a period of time, sort of a transition type thing, but that's the great thing about contracts and agreements. You can do whatever you want as long as everyone agrees to it.
That's true.
So now when you're talking about buy-sell agreements, not all agreements are created equal. You have a cross-purchase agreement and a redemption agreement. They're structured differently, and there are some pretty significant tax differences specifically related to the step-up in basis that you get. And I've got a slide that'll kind of illustrate that, so we'll kind of table that for now. The next thing is, when you have a buy-sell agreement, do you fund it or not? And I also have a slide that illustrates why people use life insurance a lot of times to fund buy-sell agreements, especially term life insurance because it's so cheap generally, as opposed to paying it out of the cash flow of the company or liquidating assets or borrowing money, that type of thing. And then the last thing we'll touch on in this section is how you structure the funding. There are ways that you can do it that will have estate tax benefits. So if we go to the next slide here, this diagram on the left side illustrates how a stock redemption agreement works, and on the right side, how a cross-purchase agreement works. And the biggest thing that you just need to know here is that the middle box on each side is the entity that actually does the purchase of the shares. So in a stock redemption agreement, the company buys back the shares from the deceased shareholder's estate. So they are redeeming their shares back to the company, which is why we call it a stock redemption agreement. And when that happens, there's no step up in basis. And I'll explain that in just a little bit. But if you go over to the cross-purchase side, you'll see that shareholder A, who is the one who's still living, is the one who personally purchases the shares of shareholder B from the estate. Now, when you do that, they've actually paid consideration for those shares. So their basis in their ownership of the company is stepped up by the amount of that purchase. Now, if you do have a pass-through entity, like an S-Corp, LLC, that type of thing, you will get a partial step up in basis with a stock redemption. But to illustrate the point, we're just kind of sort of overlooking that for right now. So the next slide here explains in numbers exactly what we were talking about. So let's assume in this case, it looks like I just inflated the value of our company by $10 million at least. So let's assume we have a $20 million company because we like nice round numbers. It makes the math simple. And let's say that Elise and I own this company and we each put $1 million into it to start. So our basis is $1 million. And I'm going to kill off Elise. She passes away and I am now obligated, obligated to buy her back. Let's say we do it through a redemption agreement. Our company owns a $10 million policy on Elise. The cash comes into the company. The money goes out to Elise's estate. And now I own a $20 million company and my basis is still $1 million. If I later sell the company, I have a $19 million gain, just rounding the capital gains tax to 20%. That's $3.8 million. And we're looking at $16.2 million net. So now let's say that we have a cross purchase instead. And so when Elise passes away, I actually own the policy on her. I'm the owner and the beneficiary. So the $10 million comes to me. I can't run off anywhere with it because I have an obligation to buy those shares. But see, now I'm actually paying the $10 million. So my basis gets stepped up to $11 million. If I later sell the company, my gain is only $9 million. 1.8 million in taxes, 18.2 net. Basically just having one type of agreement over the other saved $2 million in taxes.
So now why would somebody not do the cross purchase then?
Another good question. That has to do with cross purchase agreements. When you have multiple shareholders, can get unwieldy. And so if you had, because you think about it, you have to have, if you're funding it with life insurance, I've done it with as many as 3 partners. So each partner has to own a life insurance policy on the other. So if you had 10 partners, then you'd have, I don't even know how many that is, 9 times, I mean, a lot of policies.
Right.
And so that's one reason they don't do it. Now
you have to have a policy on each person?
Exactly.
So each one has to have on each of the others?
Yes.
Oh, wow. Okay.
Yeah. So now you can't avoid that. You could create a partnership to own the policies. Then you can do some creative things, but that's the reasons why I've seen cross purchases not done. The other thing is that a lot of times boilerplate buy-sell agreements, the default language has the company doing the buyout, and people just don't think through the tax consequences of it.
Now, is there a factor, I know I've seen with business partners, and I've heard this before, where the age of the partners makes a difference as well? Does that make a difference? Like if one partner is significantly older and less insurable or more expensive to insure, does it matter which one of these plans, or that doesn't factor in at all? Yeah, you would have the same problem under either. That's just a function of how you would fund the buy-sell as opposed to what type you have. But in that case, when you do have some inequity as far as how expensive the premiums are, if you think about it, really, even if I own the policy on you, you own it on me, our company is going to bonus us out the money. So it's really going to be the company paying for it anyway. Okay. So even though the premiums are different. So this slide sort of illustrates why it makes a heck of a lot of sense to use a simple term policy to fund an agreement instead of trying to fund it out of the operations of the business. So in our example, Elise passes away. Let's say I do not have life insurance on her. So now I've got to pay her estate $10 million over 10 years plus interest. And that's obviously going to be an after-tax payment. So if we assume the 4% interest rate, we were feeling generous with the interest rate, and the income tax rate of 35%. So I've got $1 million of principal each year plus the interest, which will be declining. So that total payment is between 1.36 and $1 million. But it's an after-tax, so the profit required there all adds up to $17.1 million in profit just to pay off a shareholder who has passed away. And if you take that one step further, this is where it really hits home with a lot of business owners. What kind of sales do you have to generate in order to have $17 million of profit? If you assume a 25% gross margin, you're looking at about $68 million in sales that was purely earmarked just to buy out. So you can't use that to reinvest in the company or take distributions or anything really. So
it can really hamper the operations and ongoing viability of a company. And that's why a simple term policy makes a lot of sense. So this last thing is, again, if you're in a situation where you have an estate tax and your business is part of your estate, then the question is, you can fund it one of two different ways. On the left there, you'll see what we call the typical way. You set the buy-sell agreement at $10 million, like we were saying, but that's part of my taxable estate, or in this case, your taxable estate, because you passed away. And so, your heirs would pay 40% tax on that, and so they would net $6 million. Well, let's say you and I could agree that, hey, we like 20 million as the value, but who's to say it's worth 20 million or 12 million? Most assets have a range of fair market value, especially a closely held company. So we could justifiably argue that our business was only worth 12 million. Well, in that case, we set the buy-sell agreement at 12 and we get a policy for 6 million on each of us. And that would flow through our taxable estate. And in this case, there would be $2.4 million of taxes on that, and they would get the heirs would receive 3.6 million. But if we still wanted the whole 10 million, we could just take and put another life insurance policy out into a life insurance trust, which would avoid all the estate taxes on it. So the heirs would get that whole amount. So just by splitting the coverage and structuring the buy-sell differently, you could save $1.6 million in taxes, which isn't too bad.
That's very good. And that trust, the life insurance trust, we call that an ILIT, an irrevocable life insurance trust.
So we'll talk just a few minutes about this next category, which is where you have no partners in the business, but you have family members. So sometimes you could have family members, even children, and a buy-sell agreement still makes sense. And you could fund that with life insurance, especially if it's a situation where a father or mother and a son or daughter kind of started the business together, in which case they really are partners, and maybe you have a buy-sell agreement, something like that. But more often than not, you have where one generation starts the company, the other generation is coming into it, and at some point they'll take over the company. And then the question is, if you're in a state taxable situation, how do you get that business down to the next generation? And the answer is, you really just make sure you do good estate planning. So you're going to generally leave the business via your will or revocable trust. And you're going to want to make sure you deal with estate taxes. And I always say that when you're doing estate planning, you're really just doing 4 things at the end of the day. And there's a lot that goes into these 4 things, but they can be simplified by saying, number 1, you want to make sure you're effectively utilizing all your exemptions. So that would be your annual exclusion of $15,000, your lifetime exclusion, which is currently $11.4 million, but earmarked to drop back down in 2026 to $5 million plus inflation since 2010.
That's not 6 million.
Yeah. So most people think it'll be around 6 to 6.5 by the time that comes around. And then there's also, which I won't get into now, there's an exemption that actually can become pretty important called the generation skipping tax exemption. And you just want to make sure that your documents are drafted by somebody that knows what they're doing and is incorporating all those exemptions and taking advantage of them. Typically going to want to have lifetime trusts for the next generation, etc. So that's the first thing you do. The second thing, so now we've avoided as much tax as we can by utilizing our exemptions. Second thing we want to do is discount assets, make them look like they're worth less than they are. We actually have a slide on the next page to talk about a limited partnership. That's one way to do it. You could also recapitalize the stock of a company into voting and non-voting. And the reason you do that, arguably, the non-voting is not worth as much as the voting, so you can get a discount there. So once you've avoided tax, you've discounted, the third thing you try to do is shift growth outside of the estate, because a lot of people make the mistake of doing their estate planning with a snapshot in time currently, whereas they're not going to pass away for 20, 30, 40, 50 years. So if you're able to take assets, especially assets that are growing pretty quickly, and get them outside of the taxable estate, we can even do it in ways where you can maintain control and beneficial use of the assets. then obviously that's a good thing. So as an example, you take $1 million, you get it out into trust, it grows to 10 million. Well, you just save the taxes on $9 million. So that's something, and there's all kinds of ways you could do that. Sales to trust, which we're going to talk about in a little bit, just plain old gifting. There's grantor retained annuity trusts. The list goes on and on. That's where a lot of the creativity in estate planning comes in. So now you've done the first three things. You've avoided tax, you've discounted assets, and you've shifted growth. So you've really kind of pounded down that tax as much as you can. And then the question is, well, what do you do about the balance?
How do you pay it?
Right. So the taxes have to get paid within 9 months of the date of death. And so at the end of the day, there's only 4 ways that those taxes are going to get paid, because they have to be paid in cash. So you either have cash lying around in the estate, which that'll be a dollar for dollar type of thing. We have a slide that illustrates this a little bit later. Mm-hmm. You can sell off assets, which is going to be dollar for dollar plus some liquidation factor, because more often than not, you're not going to get the full fair market value because you have to sell it so quickly. You could borrow the money, that's dollar for dollar plus interest, or you could use life insurance. We have something that will explain why some people consider to do that.
So one of the ways that you can discount the estate is by using the family limited partnership. Now, there are many different nuances to limited partnerships. You can have family limited partnership. You can have an asset protection limited partnership. We use them a lot in our practice for asset protection, but they double from an estate planning perspective as a way of getting discounted gifts and distributions at death. So essentially the way it works is the limited partnership is comprised of a general partner and a limited partners. It can be multiple general partners and multiple limited partners. But where this entity differs from other types of companies is that it does not matter how much the general partner owns. They can own a very small fraction, but the general partner is going to control the entire partnership. So what generally happens in a way of getting a discount in some of the gifting that's used with the limited partnership is that you can gift to the next generation's limited partnership interests without giving those limited partners any control. So the next generation would get assets, they'd get parts of the business or whatever else you're using the partnership for, and they would have all the appreciation for those assets shifting out of the original owner, called the parent, estate for estate tax purposes. And the IRS says, well, if you're, and they still recognize this, it was slated to go away a few years ago, but then we had a change in presidency and we still have this discounting. Where it's going to go from here, who knows? But right now it's still on the table. So what happens is that the IRS recognizes that what you give as a minority interest, because it lacks control and because you can't just sell that interest on the open market, they recognize a discount. So for instance, if you have something that's worth $10 million, that's its actual fair market value, depending on what that asset is, the IRS will let you take a valuation discount and go from 10 million to a lower value. If it's real estate, it might be a pretty, what would you say, Scott, on a real estate discount? You could take like maybe 30 something or other. I mean, it's all going to depend on what your CPA and tax attorney come up with. But you have a much greater discount than, let's say, if it was cash. Sure. It's hard to tell the IRS, well, there's $10 million in the partnership account. I'm giving 5% limited partnership interest and it's worth, we're going to discount that by 30%. They're not going to take that well, but you can get some discount on it. But a business, a closely held business, if it's used with the limited partnership, you can probably get a fairly decent discount because, again, the limited partners have lack of marketability and they have a lack of control. So it does allow for discounting and crunching the numbers and, really reducing the amount of taxes that'll actually have to be paid. Anything you want to add to that?
Elise, can you put an S corp in a limited partnership?
So the answer is you really can't. However, Scott, interestingly enough, if it's and I'm not sure I buy into this, but I've seen it done. We generally go with a no, but if the partnership has no other owners but the one owner, which let's face it is really defeating the purpose, but I have seen it, then you can do the S Corp. So we don't agree with it, but I have seen it done. It is absolutely not recommended. You'd be defeating the partnership for our purposes. But yes, I actually have seen it.
Seems like it'd be simpler and more straightforward just to do a stock recapitalization in that case, right?
100% agreed.
Yeah. So this next slide illustrates what we were talking about before. When you're in a position, you've done what planning that you can, but you still have some amount of estate tax left over. So for each $1 million of estate tax, what are your options? So you see here on this bar chart, the purple option, that's the cash. Very simply illustrates with a graph for every dollar of tax, that's a dollar of cash that you have to pay. The green bar, that's the liquidation. And again, like we said, you have 9 months to pay the taxes. Most people end up knowing that. You're generally not going to get fair market value. We show here a 10% valuation discount or valuation adjustment based on that. But it could be a lot more. There's the famous case of Joe Robbie and the Miami Dolphins and how he ended up selling to Huizinga to raise $35 million. Well, not him, his heirs. And how, Wayne Huizinga got quite a deal when he bought it because they needed the money to pay the estate taxes. And then that blue, that's borrowing. You could either borrow from a private bank. You could also sort of borrow from the government by paying your taxes over time if you qualify. And that has to do with the size of your estate and how much of it is made up by your business, et cetera. But at the end of the day, you're still borrowing. It's dollar for dollar plus interest. So that's why a lot of smart, wealthy people use life insurance simply because that orange bar is smaller than the other ones.
Way smaller, actually.
And this is an example. We have two slides that are almost identical, except you'll see in the bullet points to the left there, this was based on a male who's 82 years old and a female who was 74 years old. And so a lot of times I hear, well, wait a minute, I'm too old to get life insurance. Doesn't make sense. It actually does. And when you look at the IRR calculations, the internal rate of returns, they can actually be higher when you're older, simply because you don't pay the premium as many years, even though it's a higher premium.
And the reason we have the male and female there because it's a second to die policy?
Yes. I'm glad you mentioned that. When you're using life insurance for estate taxes, we typically, if we can, are not putting the policy only on the husband or only on the wife. We use a special policy called a second to die policy that's insuring both of them on the same policy, and it doesn't pay out until they both pass away, which coincidentally is exactly when we need the cash for estate taxes. And the reason we use a policy like that, typically it's the premiums will be around half of what it would be on the husband and about 75% of what it would be on the wife. So it's just a more economical way of doing it. This next slide is the exact same situation, except this was a 49-year-old and a 42-year-old, just to again show you that life insurance is something that should be explored when you're looking at this, when you're dealing with estate taxes. So the last area of business succession is this sort of murky area where you don't have any partners in the business, you don't have any family members, but you're still thinking about wanting to continue the business past your lifetime or past your retirement. And what do you do? How do you do that? The number one thing that you need to do is find the key person or key people who are going to take over from you. Can't emphasize that enough, because more often than not, businesses end up going out of business once the main person leaves or passes away because nobody is there that has the business acumen to do it, or the industry knowledge, the relationships, that type of thing. So who's that going to be? And then if you find that person, do you do a buyout with him or her? Or is that person just going to run the company for the benefit of your heirs who are going to be shareholders in the company at some point? This is where it gets really murky. It really depends upon the circumstances. A lot of my clients are still active in the business. Maybe they're in their 60s, 50s, even 70s, either way. And maybe they have kids that are in the business, but maybe the kids are just kind of working there and they're not sure that they're going to be working there forever. So do you come up with this grand plan to get them the business when they may or may not actually want the business? So sometimes there's a wait and see approach that you can take, and you can just use some hybrid examples there. So the second thing you could do on here, you could set up an ESOP, an employee stock ownership plan. There's some tax advantages for the company, or rather for the owner when he sells the company into the ESOP. An ESOP is basically just a qualified plan that's designed to own shares in companies. You can retain some control if you do it. It can get a little complicated in my experience. There are a lot of ESOPs out there, but a lot of times it's looked at and talked about, but doesn't get done as often.
You have to value that each year, right?
Yeah. Mm-hmm.
Right, so it's pricey.
Yeah. So more often than not, people just, sell the company. And obviously we're talking about once you've already gotten past, I'm not going to sell the company. You're still trying to figure out a way to keep it going. So in any scenario, again, developing the key person is critical. And as I mentioned before, you have to transfer not only the operational knowledge, but the biggest thing that people forget to do is transfer client relationships. We see this even when, generation one brings in generation two, and maybe they'll, sit in some meetings and things like that. But let's face it, a lot of business gets done through relationships. And so maybe they'll go to lunches and not take generation two with them. They'll go golfing, not take them with them. So they're not really transferring those relationships as well as they should. And so when generation one leaves the company, generation two really doesn't have they might know who they are. They don't have a strong relationship. So the other thing too is that in developing key people, some companies they limit their looking to just people who are already inside the company, but sometimes you have to look outside who your current employees are. You might need to go out. Actually, companies that specialize in that specific type of talent search, finding people who can come in and run companies for the next generation.
Well, I think one thing that gets missed is business succession is not just about who's going to inherit the money that would be there if somebody bought you out, but also if the company is going to die with you, then what about all of the infrastructure, all the people that are currently employed? They're going to be out of work.
Yeah.
So, you kind of have a responsibility if you're running a company to make sure that there's some place for these people to go.
That is true. So on this slide, we're really, and this is the last one related to business succession, we're really talking about, let's say you do find a key person. Well, how do you actually get the company to them? And this is a bit of a conundrum. And I've been on conference calls with business owners who they found the perfect person, or they've had a key employee that's been with them for 15, 20 years, and this is going to be the perfect person, but that person doesn't have the funds to buy the business from them. So are you going to sell or finance over a period of years? And if you think about that logically, if you say, okay, I'm going to sell the business to you for $5 million and I'm going to let you use the operations of the business to pay me, well, you really just gave the business away. Because you owned it, you could have kept that income and kept that person employed. So really the only thing you've traded away is that you don't have to be there working anymore. So it's not necessarily a bad thing, but you kind of need to think through that. So what I've seen is that sometimes they will structure a situation that'll say, look, the first half, 50% of the stock will do seller financing. So the operations of the business will pay me back, but then you'll have the wherewithal at that point in time, because you'll own 50% of the business, to go get a loan and pay me, immediately the rest of it. So you can do some things like that as well. And this last bullet point here is just, or number 2 rather, is just talking about the fact that when you find that key person, there's different compensation arrangements and things like that that can retain them, keep them tied to the company. You can do stock grants and bonuses. You can create a phantom stock plan. There's some code sections that allow for some special bonusing. You can either do it with or without the gross up to pay the taxes. And then you have non-qualified deferred compensation plans as well. Those come in all different kinds of flavors.
Because you have to incentivize the person to stay.
Yes. Yes.
So I want to kind of wrap things up with two other concepts from a tax planning strategy. And these are kind of complicated, but I just want to go over the basics of them. So everything in estate in taxes, Scott, I'm sure you'll agree, is some sort of acronym. So this one is known either as an IDGT or an IDIT, which is basically the intentionally defective grantor trust. So what does that mean? So grantor is generally the term that we use. A grantor or a settlor is the person that creates a trust. And when you have what's called a grantor trust for tax purposes, it means that someone, generally the person creating the trust, is the one that's still going to be responsible for any income tax on the earnings of the trust. So in this case, what we'd be doing is the grantor or the business owner would create an irrevocable trust, would have no benefit from that trust, would transfer or sell the assets of the business itself or the assets to the trust in exchange for a promissory note that does have to be paid back at a reasonable interest rate. Now, it could be the lowest rate permitted, the AFR, the applicable federal rate, but there has to be some sort of interest in it. It has to be paid back. There are different nuances to it as to how much you actually have to fund the trust with in terms of cash so that there's a reasonable ability of the trust to pay back the owner. But what it does is it allows the ownership, the value of the business to be moved out of the taxable estate of the owner, and it freezes the value so that all appreciation is going to grow outside of the grantor's estate. But the grantor is still paying the income tax. And then if their estate is high enough that they're worried about having to pay estate tax, then by virtue of paying the income tax, they're also reducing their estate for estate tax purposes by the amount that they pay in income. So now they're taking money out of their estate that would otherwise be taxable at a rate of potentially 40% by paying this tax. And then the other concept, which is a little bit newer, and IRS doesn't really love either one of these things, and there's not a lot, especially with this one I'm about to talk about, there's not a lot out there on this. There's a couple of private letter rulings, but they are legal strategies. They have to be done very carefully, but it's another way of getting the business out of your taxable estate. So this one is called the BDIT, the Beneficiary Defective Inheritance or Inheritors Trust, depending on who you ask. And essentially the way this one works is the grantor is not the business owner. It's generally maybe a parent of the business owner who creates an irrevocable trust, puts in maybe $5,000, and names the business owner as the beneficiary. You generally name the business owner can be a trustee, but you generally have an outside person also be the independent trustee. And where this one differs is that you're selling the assets in exchange for a note, but in this case, the income tax responsibility is not on the actual creator of the trust, but on the beneficiary who is the owner of the company. So that beneficiary is considered the owner for tax purposes because of certain provisions that are put in the trust. So the good news here is that whereas with the IDGT, once the trust is created, that grantor has no other means of getting any money directly from the trust, whereas in the BDIT, this beneficiary / owner actually can get distributions for health, education, maintenance, and support from the trust. And again, there's a note, and the note does have to be paid back, and the value of the note is still included in the taxable estate of the owner of the business. But it's a way of getting the business out, getting the value of the business frozen, and also its creditor protection to the beneficiary because it's an irrevocable trust, and the beneficiary, even if they are a trustee, can only get what we call the ascertainable standard of health, education, maintenance, and support. So it's kind of a complicated concept, but it's something if you're a business owner and you have a very high valued business, it's a way of transferring your business, both of those, without actually using any of your estate tax exemption, which is great.
Yeah.
If you do it correctly, except potentially for the initial, some funding that'll give the ability for them to pay the money back.
But to be clear, just one comment on that.
Mm-hmm.
What you're really doing is transferring the future growth on
Correct.
the company, right? Because you're taking back that note.
Right.
So the way to think about that, I guess, is that and it doesn't even have to be the business, it could be any asset.
Correct.
And if it's going to, say grow by 8%,
mm-hmm.
but we have to take a note back where it has to pay us back 3%, then that 5% growth is what we're doing it for in both of those.
Right.
scenarios.
You're getting the appreciation outside of the estate. So I want to thank everybody for joining us today. And if you want to re-listen to the webinar, it should be on YouTube within the next couple of days. And if you do have any questions, feel free to reach out to us. If you want to have a complimentary preliminary consultation, or if you're interested in any copies of our books, please feel free to reach out and we'll be happy to help you. Thank you so much and have a great day.